Welcome to today's program titled 2024 Trade Secrets and Non-Competes Key Trends and Insights. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you will recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Jesse Coleman, Robin Marsh, and Mike Wexler. Jesse,
Thank
Robin,
you.
and Mike, you may begin.
I appreciate it. Thank you very much. Welcome, everyone. Thank you for joining us today in the first presentation of the year by Seyfarth from its Trade Secrets and Non-Compete Practice Group. My name is Jesse Coleman. I'm here with my colleagues, Mike Wexler and Robin Marsh. If we go to the next slide, please. Provide a quick legal disclaimer. You can read it. We're not your lawyers unless we are. And if you'd like us to be your lawyers, please reach out and we can talk about it. But what we're doing here today is not legal advice. It's for informational purposes only. So with that out of the way, let's go ahead and introduce our speakers. In the next slide, Mike Wexler is one of the co-chairs of the Trade Secret Restrictive Covenants practice here at Seyfarth. Has worked many decades within this area and commercial litigation. I've had an opportunity to work with him and try a number of cases in this space. I am a partner at the Houston office in the litigation group and have over a decade in the trade secrets non-compete space. And Robin, coming back up to Chicago, also equally experienced in trade secrets, non-competes, and in general litigation. So this is an area near and dear to our hearts. Hopefully we've had a chance to share some of our thoughts with you on these topics before. This is our annual presentation as to what you likely saw in 2024 and a number of things that you are likely to see in 2025. So we can probably hit the next slide very briefly, introduction and overview. Allow me to give a quick agenda set, if I can, on the next slide and tell you what you can expect to hear. I'll be sharing the federal landscape, what we've seen in particular with regards to restrictive covenants. 2024 was a very exciting year in the space of trade secret non-competes. And I'll talk to you about the forays of certain federal agencies into this space. You may have heard some of this in our 2024 recap in December. Kate Pirelli and I had the opportunity to share some of that information. There have been updates, as you can anticipate. Some of the things that we said will likely happen have indeed happened as early as this morning, and other things have developed, and we have some updates in that space and what we can expect in 2025. Once I've provided that federal landscape, Robin is going to talk to us about new state legislation, some key judicial decisions in that area, and provide a recap on where things are happening with California's new non-compete laws. From there, we'll switch over to Mike to talk to us about some federal developments in the trade secret space, some of the key cases that happened this year that shape trade secret law. As you know, this is a continually updating, developing area of law, along with computer fraud, which often bookends a trade secret case. And we'll share along the way and at the end some practical tips and some suggestions on how to maintain protections over your confidential information, confidential proprietary and trade secret information, and how to ensure that your restrictive covenants are reflective of the legitimate business interests that you're seeking to protect. So with that, let's go ahead and jump into my section of this, the federal update. If you have been following at all the trade secret and non-compete law in 2024, you've heard a whole lot about the FTC rule banning non-competes. It is not dead in the water at this point, but I would argue it is very much on life support, and we can talk a little bit about that. Let's, as a brief recap, next slide, to kind of level set here, it was actually initially a proposed rule in January 2023, received tens of thousands of comments that were provided. It would have been a federal ban on non-compete agreements between employers and workers. Workers was a very broadly scoped term. It would have been for all U.S. workers. Did not apply directly to non-solicits unless they had the functional equivalent of being a non-compete. There was also, similar to the California law Robin will be talking about, there was a notice requirement. The effective date was going to be September 4th, 2024. There's no private right of action. However, there was FTC enforcement powers, which could have included injunctive relief and a civil monetary penalty. So that's the general contours of the rule. As you can imagine, this would have greatly impacted, being a 50-state ban, employers throughout the country. And in fact, throughout the summer of 2024, there was a great deal of electronic ink spilled on this topic and how it would apply. Lawyers throughout the country providing webinars, not unlike this one, advising on what may or may not happen next. Next slide, please. And what we saw were 3 major lawsuits. There was one in the Northern District of Texas, another in the Middle District of Florida, and then another in I believe, the Eastern District of Pennsylvania, which we're going to go through very briefly. Next slide, please. The Northern District of Texas case actually started out as 2 cases. They were consolidated. There was a challenge to the FTC strongly on the rulemaking authority, whether or not FTC had the substantive rulemaking authority under the FTC Act, whether or not the language there would support it. This was an APA challenge, Administrative Procedure Act challenge. Ultimately, there were a number of other arguments that were made as well, whether or not constitutionally the FTC had been appropriately delegated the authority, whether or not there was a major question to be addressed here. Judge Brown didn't address any of that. She focused entirely on the APA front. She found the FTC lacked substantive rulemaking authority, found that the process or the rulemaking the FTC did was arbitrary and capricious. It was unreasonably overbroad. Failed to make a rational connection. She originally issued an injunction that had just to do with those parties that were in front of her. But ultimately, the case got fast-tracked to summary judgment, at which point Judge Brown set aside the rule, which is the language in the APA. Has nationwide effect. Some have described this as a vacator. Not sure if that's what Judge Brown would specifically describe it as. She was careful to use the language of the APA. This case is now on appeal before the Fifth Circuit. There has been some briefing on this. In particular, the FTC filed this brief November 4th. The appellee filed their brief January 15th. There's been an an avalanche of amicus briefs in this and in the other case, including a group of Republican states attorneys general. And so we'll see where this goes. It is interesting that there is some question at the Supreme Court whether or not a district court has the authority to set aside for the entire country. There has been some citing to Gorsuch, Justice Thomas, Justice Gorsuch, Justice Barrett, and some language in some cases in their concurrences as to whether or not they have that authority. I guess we may see it in this case, we may not. One thing that has been interesting here is with the new administration, there may be less of an appetite to support these cases. And so there has been some attempted interveners. A small business majority is what they call themselves, and a couple of individual parties seeking to take over the defense of this rule. Not surprisingly, the government has declined that offer and filed an opposition brief, as has the Ryan Party. And so we'll see what happens and whether this is an exceptional enough case for that to happen. Next slide, please. We also have the Property of the Villages case. This case is in Florida. This involved an individual's real estate company whereas Ryan involved a number of groups, the Chamber of Commerce, for instance, along with an individual. This was an individual real estate company. They brought an injunction. They were granted injunction, this to the individual company itself, Property of the Villages. And the court there in the Middle District of Florida did not stay it or otherwise take action that would impact the rest of the country. What it did do is find on grounds that Judge Brown in the Northern District did not find, and that is it looked at the constitutional issues. It looked at the major questions doctrine, and it found that this rule violated the major questions doctrine. And so has some additional language there. This is actually up before the 11th Circuit. It's moving more quickly in some ways than the Ryan case because it got there on the preliminary injunction side as opposed to a final ruling. There was a denial to hold the proceedings in abeyance pending the Ryan case. So it'll be interesting to see how this plays out. Again, we have the small business majority here as well seeking to intervene. Opposition briefs. No one has said anything from either of these circuits yet as to whether that will be granted. Next slide. Finally, a footnote on the FTC piece. There was a third case, Eastern District of Pennsylvania. The court there denied the motion to stay an injunction, finding plaintiff failed to show irreparable harm. The FTC actually had the authority to promulgate substantive rules, and that the rule did not violate major questions of the non-delegation doctrine. Unfortunately, I think in some ways for, I guess, the parties there, or the FTC as it stood in 2024, this will not go anywhere. This is a decision as to what the likelihood of success would be. It's not a final decision, and there's going to be no appeal. So this case is kind of an outlier in the sense that there was no final determination on the merits. This was simply a denial of a motion for preliminary injunction. So there is no circuit split to speak of on this issue, and the dismissal was essentially at the prompting of the judge. When the plaintiff sought to stay the case, the judge said, "No, I'm going to move ahead with this unless you decide to dismiss it," and so they did. So that's the end of that one. Next slide, please. We've seen some other enforcement actions by the FTC. Whether or not the rule will survive Fifth Circuit or 11th Circuit, of course, is just reading the tea leaves. Those circuits both have enough judges on them, of course, to uphold the district court decisions, or it could go differently. But we do see some enforcement actions that are separate from the final rule. Next slide, please. I will not go through these in any great detail given the time and that we've presented on these before, but the first two cases were consent orders that the FTC unveiled at the time that it unveiled its initial final rule, saying, hey, look, here is our expertise. We have expertise in non-compete space. Look at these consent orders. They also then went to town on a third company, Anchor Glass, during this time frame. But again, this was not in enforcing the final rule, but acting under its authority to regulate unfair competition generally. So these were not in enaction of the non-compete rule, but going after non-compete agreements nonetheless, finding that under their other authority to regulate unfair competition, that these violated that. Next slide, please. They've also gone after no-hire agreements. We've seen that with the Guardian Services industry case and the Planned Building Services. These are both up in New York City and northern New Jersey. No hire provisions, which are separate from non-compete provisions, but essentially prohibiting the contracting parties from hiring employees of these organizations. So these have come out, proposed consent decree. Again, these are not going to be affected in any substantive way by whether or not the rule ultimately survives, but they are exercises of the FTC's authority. Next slide, please. We've also seen some merger guidance activity. Next slide, please. Potentially more within the focus of the uncontested areas of their authority. I say that lightly. There may be challenges. The FDIC has approved notice seeking public comment on its proposal to revise the statement of policy on banker transactions. One proposed revision would have prohibited non-compete agreements in bank mergers. On September 27th, there was a final statement of policy issued then in the Federal Register. Next slide, please. In October of 2024, the FTC voted unanimously to adopt new rules for the pre-merger notification form and reporting process under the Hart-Scott-Rodino Act, with the intent to improve the ability of the FTC and DOJ antitrust divisions to detect illegal mergers and acquisitions. There's a requirement to disclose the existence of non-competes and non-solicits amongst the businesses, and we've seen a lot of the same type of public comments received as for the proposed ban on non-competes. Next slide, please. This rule was ultimately published on November 12, 2024, will go into effect February 10th, and we'll see whether it spurs litigation in advance, just like the ban on the non-competes did. Next slide, please. So what is the impact of the new administration? Well, Chair Lena Khan, who spearheaded the FTC ban on non-competes, has announced she's stepping down as chair and leaving the commission by the end of January. Andrew Ferguson, who has dissented routinely on the final rule and in related rulings and statements, is a current commissioner, and he's been nominated, or he has been assigned by President Trump to replace Chair Khan as chair. Currently, the FTC has a 2-2 split, and until Trump's pick, Mark Meadow, obtains Senate confirmation, we have this Democrat-Republican even split. It'll be interesting to see whether the Trump administration drops its legal fights for the 5th and 11th Circuits or let them play out, but we can't expect overall changes in the direction of the FTC. Next slide, please. In addition to what we've seen with the FDIC and the FTC, we have some updates with the National Labor Relations Board. Next slide. We saw in 2023 what was known as the Abruzzo memo that held that it was the position of the General Counsel's office that non-competes violated Section 7 of the Act, National Labor Relations Act, and they could be construed as denying them the ability to quit or change jobs. Next slide, please. We saw the NLRB General Counsel's office double down on this in 2024, and also identifying that stay or pay provisions that you can see here also may violate, and there's a rebuttable presumption that they violate Section 7 unless certain elements are met. Next slide. The GC wasted no time in seeking to get this new position enforced. There were a couple of wins out the gate. Some of these were wins by concession. They agreed. They threw their hands up and said they're agreeing to withdraw. In one case, it was a no poach provision as opposed to a non-compete. That's the plan companies, which you may have seen also earlier with the FTC going after them as well. The plan companies. Organizations. There's also been a couple of losses because there is a robust level of case law addressing that non-competes do not violate the Act. And at least one ALJ said, look, it's up to the board to make this type of precedent, not me. Next slide, please. So the impact of the new administration, well, we learned this morning that Ms. Abruzzo has been fired. That was expected with the new administration. We anticipate President Trump will likely appoint a new pro-employer general counsel forthwith. There will be a change of policies, the rescission of these conflicting GC memos, and a redirection of priorities. We also anticipate that maybe some of the pro-employer stance may be tempered by a blue-collar sentiment within a wider, less conservative Trump 10 of 2022. Some comments by J.D. Vance, for instance, indicate that might be the case. In any case, it's undoubted that Trump will try to regain the Trump administration control of the partisan board. However, given the way that works, it'll probably take until 2026 for that to happen. So in brief recap on the federal update, next slide, please. Federal agency rulemaking on non-competes is less likely in 2025. Different agencies, however, still have the authority to go after restrictive covenants individually. some of those earlier enforcement actions, again, were not contingent or relying on the proposed final rule, nor could they. If we're going to see some 50-state restrictions, I would keep an eye on Congress. That's going to be less subject to successful court challenge, and where the authority may more strongly lie. Whether there can be a cobbled together of enough of a group to do that remains to be seen. Meanwhile, it's the states, as they have been in the past, and will be again, I think, this year, to be the hotbed of legal change. And with that, let me turn the time over to Robin to talk to us about some of the state changes.
Thanks, Jesse. He's right. This is a hotbed, and where things are happening, we'll get to it in a little bit later on, but I wanted to start with some key changes that happened in 2024. Next slide, please. I won't belabor a lot of these since I know these were discussed ad nauseum in 2024, but a big issue was what was happening in California when they amended their laws to be even more forceful when it came to their disdain for non-competes. So one of them, effective January of last year, was that if an employee lived in another state, signed an agreement in another state, was subject to law in another state, but then moved to California, they could be relieved of those contractual obligations. California is very employee-friendly and wanted to amend the law to say that a contract couldn't be enforced from out of state against one of its residents when they joined, and it would be committing a civil violation to try and do that. It also expanded the scope of the non-compete ban, which required companies to notify employees as of February 14, 2024, that any agreements that they had were null and void. And if companies did not do that, then they were open to civil penalties. We saw some PAGA actions, Private Attorneys General Act, that were popping up because employees were suing to be relieved of those obligations, especially if companies were not complying with the new California law. Next slide, please. Colorado also made some strides to crack down on some non-compete laws and amending its statute. One of them was the Attorney General Restrictive Employment Agreements law, which was signed to kind of put tighter leashes on companies that were trying to recover for repayment of training expenses, also referred to as training repayment agreement provisions, TRAPs. That went into play in August of 2024. This, of course, doesn't refer to just regular on-the-job training or generic training that happens with being in the position. It's highly specialized training that requires a significant investment by a company, that they're subject to agreement and being repaid. So those increased penalties for those that are overbroad or abusive, such as trying to recover expenses for normal on-the-job training that everybody gets, not specialized training. And it has significant penalty provisions, 3 times the amount of the attempted recovery, plus $5,000 penalty for doing that, plus attorney's fees and interest, which is a rather fervent disincentive for people trying to abuse use of TRAPS agreements. Next slide, please. Illinois did 2 new provisions effective January 1 of this year, adding exemptions to non-compete and non-solicit agreements since it started trying to revamp its laws prior to COVID and again in 2022. So it prohibited the enforcement of non-competes and non-solicits for mental health professionals, but those that were providing health care to veterans and first responders, and then gave even more nuance to it if the enforcement was likely to result in an increase in cost for that veteran or first responder seeking mental health services. It also gave a clarification on construction workers as to whether or not they were covered by a collective bargaining agreement. Next slide, please. We see a lot of other states making changes, a lot of them in the healthcare realm having to do with primary care physicians or nurse practitioners or nurses making sure that whether or not non-competes were applying to them and putting further restrictions on that. Listing out Iowa, Louisiana, and Maryland, for example. The next the next slide. Minnesota, we've seen making strides in the past couple of years, and this one limits the use of no-poach agreements between service providers. So companies acting kind of as a go-between for work contracted or represented by a customer and their customers. That became effective in July of last year. And again, Rhode Island having to do with healthcare workers. Next slide, please. A real notable state, kind of following the trend of what was happening on the federal level, was Washington. They expanded its law, making it much harder to enforce non-competes and stating that any restrictions and exceptions thereto would be narrowly construed. The new amendments are very specific. No non-competes can be longer than 18 months unless the party reaches the rigorous standard of clear and convincing evidence that longer than 18 months is warranted for that particular individual. It must be disclosed at the time of hire or supported by consideration if it's during employment, and continued employment is not enough to support the enforcement. If the employer lays off the employee and intends to enforce that non-compete, they have to pay that employee the equivalent of their base salary for the duration of the period. And it also expanded the definition of non-compete to include non-solicit restrictions. And that went into effect in June of 2024. Next slide, please. Pennsylvania also made some strides when it came to healthcare workers, modifying requirements for certain issues and how non-competes can be applied to healthcare workers. And then, interestingly, also added a requirement that a study be conducted within 3 years to see the effects of the state law. I think wanting to understand how that is going to play out is an interesting addition to the state law, wondering what its effects are. The next slide, please. So 2025 has already been a hotbed of states trying to figure out what to do in the wake of the FTC non-compete ban and how they can do it on the state level. As of right now, we're seeing at least 14 non-compete bills in 7 different states trying to figure out how they can regulate what's going on with non-competes and making sure that they are keeping up with the times. Some of them have to do with healthcare workers, and some of them have to do just generally prohibiting non-competes in private employment contracts. For example, we see the Senate bill in Connecticut that's being considered. Next slide, please. New Jersey, again, following the trend with addressing non-competes as to healthcare workers. New York has had lots of fits and starts in trying to introduce a bill regulating non-competes, none of which have really been successful up until now. We'll see where these go. There's 2 state bills, 3 local New York bills. They're all kind of conflicting and depending on which wins the day. But one of them in the state bill allowed employers to request employees to execute restrictive covenants, have a right to counsel, but they would have to give 30 business days advance notice before leaving, which is 6 weeks and quite a heavy lift for employees. So we'll see where that goes. Next slide, please. More additional laws in New York, and then South Carolina is coming into the mix. With respect to nonprofit entities, but setting a high standard, only those applying only to those with annual revenue in excess of $1 billion from using non-competes. And Washington has one requiring, prohibiting non-competes, clarifying non-solicits, and requiring employers to notify employees that they are void and unenforceable, similar to what was happening in California. And then adding labor protections to domestic workers and prohibiting non-competes there. Next slide, please. We've also seen some key cases. I think that Delaware and Georgia were on the forefront in 2024. We talked about those in other webinars, so I won't belabor them too much here. But in January 2024, there was the Cantor-Fitzgerald case where the Supreme Court said that forfeiture for competition provisions in partners and limited partnership agreements were not subject to the more rule of reason examination, but could just be favored under the employee choice doctrine, meaning people are free to contract as they see fit, and courts would examine them that way. Next slide, please. Well, in December 2024, in the LKQ v. Rutledge case, the Delaware Supreme Court further clarified its position from January of last year in the Cantor-Fitzgerald case, saying it didn't necessarily just have to apply to super senior individuals, but could also apply to middle managers or less senior employees, and provisions that required the return of benefits received versus those that are like forfeiture clauses, which have not yet vested, didn't change the analysis. And the court, again, doubled down that the employee choice doctrine was important for contracting citizens and would be undercut if people cannot rely on the law to enforce their voluntarily taken mutual obligations. Next slide, please. The Supreme Court of Georgia reversed a ruling from 2023 holding that restrictive covenants are not required to contain express geographical limitations to be enforceable. This dated back to those from a 2018 case where the Wimmer case, where it said that they had to have an express geographic term. Employers in Georgia were kind of hanging out in limbo then since 2018, unsure of how to really tailor it, but then the September 4 case from the Georgia Supreme Court said, you don't need that to be enforceable as long as you have other tailored restrictions, then you can demonstrate reasonableness. Next slide, please. Again, this is just a summary of what the Supreme Court did when it remanded, saying totality of the circumstances would govern whether or not it was reasonable and enforceable. Next slide, please. So some key takeaways, because we love to reiterate and drive home the point that this should be something that you're thinking about on at least an annual or a semi-annual basis, because laws, of course, are not introduced or changed on a calendar year basis. These are things that are consistently changing and need to have an ear to the ground knowing what is going on. So look at your existing agreements and see whether or not they're meeting the current state laws and aligning with the current legal standards, and that if you have policies that are incorporated in those agreements or mirrored, that they're also being updated as well. As of course is always the trend, you need to make sure that you're addressing your specific business needs and being careful with your choice of law provisions. We're seeing a lot of states that are changing whether or not you can impose an out-of-state law on your employees if they're not in that state, they've never worked in that state and don't really have a tie to that state. Use the agreements to your advantage, and it's not always a one-size-fits-all approach. It may seem easy to have one agreement to keep track of, but there's ways that they can be drafted to accommodate the state laws and still have it in one neat little document, making sure you're complying with the law, which is especially important given that a lot of states are now imposing civil penalties and significant monetary penalties if you fail to comply with those laws. That being said, it's important to consider those state-specific nuances. We, of course, have a 50-state desktop reference that we update annually. It's a handy-dandy tool. It's on our website, so feel free to consult that, or again, any of us. And with that, I will hand it over to my esteemed colleague, Michael D. Wexler.
Thank you, Robin. We're going to go through a few trade secret and computer fraud cases now because they provide some insight into some of the things that we should be thinking about in how we look at protecting confidential information and trade secrets and how we address problems that arise. Let's go to the next slide, please. One of the first things I want to talk about is the Motorola versus Hatera case, which is kind of interesting because In that lawsuit, the Seventh Circuit basically either expanded or further applied extraterritoriality when it comes to jurisdiction over trade secret cases. And in short, Hytera had hired some Motorola engineers. They came over, they provided certain information apparently, and Hytera was marking their product in the US as well as outside the US. And Motorola brought an action against Hytera, and they did so in the United States. And because there were acts in furtherance of the misappropriation, the court, Seventh Circuit, found, or I should say affirmed the lower court, but they found that applying trade secret law to actions occurring outside the US is acceptable, that there is jurisdiction in the US, and that if there are acts in the US, and even though there's actions outside the US, all of it can be accounted for in an action in the United States when you have issues of worldwide sales, et cetera. And in this matter, there was a $543 million damages award and included a 2-to-1 punitive damages ratio. So very interesting that it shows the scope of how the trade secret statute can be used, both in a plaintiff's action or in defending what you need to be aware of in guarding against problems. Next slide, please. Another interesting case from last year, a couple of them, Pegasystems case versus Apion. Apion sued Pegasystems, and the reason the caption and that statement don't match is because this was a second action that was filed. There was a previous action that was filed where Apion was a plaintiff, and then it was then reversed another action that was filed. But in any event, Apion had sued Pegasystems because there's misappropriation with regard to consultants and information that Pegasystems had got a hold of. And the verdict here, and it's interesting, it's a state court case in Virginia, but it's interesting because there's a $2 billion award, one of the largest awards ever in the state of Virginia and a heck around the country. But the verdict was ultimately reversed and a new trial was ordered because what the court had done there is it had excluded certain evidence, but also what it had done is it had essentially shifted the burden to Pegasystems to disprove causation and improperly then excluded evidence. And so what we have there is a situation, or maybe to take away from the cases, is that when you need to prove damages, you must show causation, and the jury instructions must reflect that as well, that the damages are tied to the actual misappropriation, the actual use and access to information. The TransPerfect case is another case that is interesting. And in the TransPerfect case, TransPerfect brought suit against Lionbridge, trade secret misappropriation. And in that case, there was some due diligence went on with regard to a transaction. And in that case, we had a situation where the summary judgment was granted for Lionbridge because the court felt that TransPerfect failed to show evidence of competitive misuse and financial harm. That the claims that were brought were very speculative, and somewhat going to the last case we just discussed, that you must show causation, you must show damages, and there has to be non-speculative evidence that tie the information that was taken or used, and it must then have show causation with regard to the damages that were incurred in order to prove your case. Next slide, please. Another interesting case from last year in the Propel Foods Phillips 66 case. Again, trade secret misappropriation case, and that information was shared to enter into into a transaction, and that information was then shared, and there was a deal was terminated, and then ultimately the jury awarded $609 million unjust enrichment damages, and saying that was willful malicious, and the award was tripled. And so the point is that even in merger and acquisition talks, care has to be taken with regard to information that's shared and what happens to the information after that transaction is either completed or most likely the transaction fell apart, and then what happens with that information. Next slide, please. In the next slide, we look at the PB Legacy case. 11th Circuit vacated an award which is approximately $10 million, where a magistrate judge had heard the case. The magistrate judge had provided answered questions to the jury and dealt with other, I'll call it jury instruction issues. And in that case, the ultimately the court, the 11th Circuit, found that the parties had not properly consented to the magistrate, and so essentially they had to have a do-over. And so I think that the tale of that case is that if a magistrate is hearing the case, and in this case the magistrate was authorized to hear issues assigned to the magistrate by the full circuit judge, and that really dealt issues of discovery and other items, but there must be a full consent if a judge is then going, if a magistrate judge is then going to hear the matter at trial and answer questions of the jury, etc. So again, lesson learned here: if a matter is being heard by a magistrate, you need to make sure that the magistrate has consent of the parties, informed consent of the parties to hear the case. In the IMAB case, in that case, the issue there was, I'll say, ownership of trade secrets, and at what point in time trade secrets were owned. And in that case, the issue there was focusing in on when the action was brought, who owned the trade secrets, and then if later there are trade secrets that were transferred to another entity through a purchase or some type of transaction, the question becomes who then has a right to bring the action. And so you want to be, make sure when you bring an action that you know who owns the trade secrets and when. In this case, I think the important thing to note is that the operative time is when the action was brought, because that's what the statute says with regard to when the trade secrets are. Even if they are transferred later, or some of them are transferred, still the entity that owned them at the time the action was initiated is the proper entity. And so that's another important thing to be aware of. Next slide, please. The Insulet case, Fed Circuit case, in that case, the plaintiff had alleged that the defendant had taken information with regard to an insulin pump, and the preliminary injunction was issued and was later reversed. The issue there is, I think that we learned from that case, is that the district court needs to clearly and definitively have the parties identify sufficiently what the trade secrets are, and that claims, when they're brought, and defining the trade secrets, that it's crystal clear as to what the trade secret is, because that will shape then what happens later with regard to all kinds of things, from damages, from the jury instructions. There could be evidence decisions made, and they relate to exactly where the trade secrets, when are they, what are they, when or how they were used, and then it ties into a lot of things that happen in trial. So the point being, it is super important to make sure that the specificity of trade secrets plays a huge role in obtaining injunctions, and then also then carrying out the trial. Next case. In the Insulet case, Massachusetts jury awarded $450 million in damages for willful malicious prosecution. Willful malicious misappropriation of trade secrets. And in that case, the award was broken down between compensatory damages and exemplary damages, and the issue there was that they hired people over from one company to the other, and if they hired some of those people over, that the product that ultimately the defendant had come up with mirrored very closely the product that was originally being used by the plaintiff. And so I think the tale here is you have to be extremely careful when hiring people from competitors, and what they work on and what information they provide and where that information comes from, or it can result in a large verdict, and it can result in a willful malicious finding and exemplary damages. So again, a tale of being cautious. In the next slide, we're going to turn to a couple of items related to computer fraud. In the first case, next slide, the accretive case. This case, wholesale insurance broker sued some former employees with regard to a trade secret claim as well as a computer fraud claim. Questions arose with regard to what are protected computers under the Computer Fraud and Abuse Act. And in this particular case, the court found that protected, in this instance, that protected computers include computers that were used across the internet, used across state lines, and that information that was accessed, there were photos that were taken, and then there were laptops that were wiped. And in this particular case, when you look at the access that was given, in this instance, there were employees that accessed information after they had left, even though they still had credentials, and that, of course, wasn't authorized access. And there's been a question among the circuits and the Supreme Court as to what is authorized access. Someone could be a current employee and access the computer and do something improper, and that may not violate the Computer Fraud and Abuse Act because of the way access is defined. In this instance, the credentials were still accessible, but the person actually was no longer an employee. So in this instance, that was improper access. The other thing that we learned from, from this case is that the unauthorized access, in particular, logging credentials, tells us that we have to have good procedures when someone leaves a company to make sure that we disconnect their credentials from the computer systems, database systems, in order to make sure that they don't have access. Because you can have questions about whether access was proper or not, and then you can have questions about things that were done in the computer system, if items were destroyed, if information was taken, etc. Next case, the Ryanair case. The Ryanair case, I guess the next case, please. There we go. The Ryanair case, Ryanair sued Booking.com with regard to what was claimed to be information that was taken from websites and scraping and those sorts of things from one company to another. And in this particular case, the Delaware jury awarded $5,000, which was a statutory minimum under the Computer Fraud and Abuse Act. You must have at least $5,000 in damages. The claim that was made was for approximately $177,000 in damages. Ultimately, the judge didn't feel that there was enough proof of loss for the dollar amounts that were claimed by the plaintiff, as well as what the jury had awarded. And the point here is that the claim damages must be directly linked to the unauthorized access and that they're quantifiable. In this instance, the jury verdict was overturned, and in this instance, various judgments, judgments after trial, etc. All those issues looked at the damages that were claimed and how did they tie to the alleged, unauthorized use or access to computer systems. And the point being here, you need to have a good understanding about damages being caused by improper access or deletion of information. Next slide. And then finally, in the Chegg case, Chegg is an online learning platform. I know a lot of students use Chegg for information and for using a source to learn new materials or to test themselves on materials. And apparently the defendant had used various bots and information to get at data that belonged that had belonged to Chegg. And despite the information that was originally accessed, there was login credentials that were apparently bypassed in this instance, and the court then had to look at exceeding unauthorized access and whether is scraping improper, and the the issue here then, looked at authorized access and scraping and public facing information, and what constitutes improper improper use or taking of information through computer means. And in this instance, the court took pretty decisive action with regard to aggressive enforcement against scraping and unauthorized access. And so there was injunctive relief granted in this case. So again, we learn here that courts are willing to issue injunctions, but you need to be able to show that there's unauthorized access and actual misuse in order to get the information. And so again, you need to look at these things very carefully if actions are brought. Next slide. I think at this point we get into some practical solutions that are helpful to folks in business in dealing with these situations and guarding against them or dealing with them when things happen. Next slide, please. Typical measures, and I'm not going to read off everything on here, but typically agreements are used with employees. You have policies and handbooks, usually in writing or on computer systems, and you have confidentiality agreements with third parties that may be vendors to you or third parties that provide some services, and you need to secure your network and facilities. And so, we look to make sure that there are passwords and systems, that information isn't available throughout the organization to everyone, that there are levels of access depending on the need for that information. We want to use locks and keys on whether it's to facilities, lock and keys to file cabinets, and we highly recommend monitoring tools. There are real-time and after-the-fact software that can be deployed within data management systems, within email systems, that will detect information being misappropriated or taken or sent out. It can detect by keywords, it can detect by files access, it can detect by size of files, it can detect by interaction with third-party email as well as third-party cloud. But those are things that are measures that should be taken. Next slide. The issue is that reasonable efforts have to be taken. And, like we said, and this talks about some of the same things we just talked about, but also you need to have, you need to take action against breaches. And that means it may be filing litigation, it may be sending a letter, it may be informing a new employer that there's an issue about information was taken. You have to have regular training, right? You can't just have a policy or have procedures, people sign agreements. You should have regular training. Maybe it's annually, or maybe it's even twice a year. An email is sent out to everyone that requires an acknowledgement that says, hey, just a reminder, we have these policies and procedures, you should be following them, and people need to click on their computer to acknowledge the fact that they're getting a reminder regarding policies. And it's very simple things you can do, and it's very inexpensive to do some of these things. There should be onboarding people when they're onboarded, and when they exit, there has to be documentation on both. Documentation when you come in, that you're not bringing things in from outside, and leaving. Hey, you returned everything. You returned all of our property, you returned all information, remind you about obligations. Again, you can have a form then or a computer acknowledgement. People sign to acknowledge what they do when they leave. Next slide, please. The reason why does this matter? Because public disclosure of a trade secret destroys the information status as a trade secret. U.S. Supreme Court. You must protect things and take efforts to keep them out of public domain. And here, the second case here, it's axiomatic that without secrecy, no trade secret can exist. If you don't take efforts to protect things and keep them secret, then in order to prove they're secret later, you're going to have a problem. Next slide. Other reasonable efforts, and we talked about it, some of this, tiered access, appropriate contracts with vendors, who has access to information. Our materials marked confidential. Can't tell you how many times we have a client where we're looking at information and they don't have a legend on it that says it's confidential. One of the things we look at is there a sign-in screen? And on the sign-in screen, when a person goes into your computer every day, does it say this is a confidential system? Everything here is confidential. It belongs to the company. And we have a policy you should be following, a procedure, and the person has to tap through that acknowledgement. Simple thing, but we look for those things. And Are there legends on documents, on Excel files, on PowerPoints that say confidential, company use only, confidential, internal distribution only, whatever. Simple steps, but those are things that show. I think there was a quote in the Seventh Circuit. One of the more prolific writers of the Seventh Circuit Court said, the more efforts you take to protect things, the more you show that the information is indeed confidential. So that's important. Also, as I'll say, we're transitioning from an at-home work economy to maybe a more in-person work economy these days. Do you have written policies, and are you making people come into the office, and how are we dealing with information and having it accessible remotely? Again, you need to decide what you're doing with those things, have policies and procedures to protect that, have training, and take action if there are breachers. Next slide. We like to talk about the ACE audit. What are your trade secrets? What are you doing with regard to those trade secrets to protect them? Create a culture of confidentiality, and then enforce. If people are doing things that violate your policies or make things available to the public, we need to take action. Next slide. Create a culture of confidentiality. We won't discuss that any further. I think we went through that pretty well. Next slide. What do you have in place? Next slide. And what are you doing? Are you using agreements? Are you marking things confidential? Are you using invention assignment agreements? Are you using restricted covenant agreements, non-competes, forfeiture for competition, non-solicits, both employees and customers, no hires, non-disclosure, confidentiality provisions? Next slide. Do you have social media policy? People put things in social media and don't even think about what they're putting in social media. Next thing you know, someone's putting information in and it could be anywhere. It could be Instagram, Twitter, TikTok, wherever, company information, thinking, oh, it's okay. I'm just tweeting about the company. So you need to have policies in place to deal with these things. Next slide. Bring your own device policy. Can't recommend enough. If you have employees and your budgets allow it, if they use computers, iPads, phones, they should belong to the company, and you have a policy. And if you allow them to use computers or phones that belong to the individual employee, then you have to have a policy with regard to how they are used, what devices can be used, what information on the devices belong to the company. You need to really look at that issue. If you gave our best practice, those devices should be purchased and provided to the employee by the company. The company owns them, and they should be used for work purposes. And then the company has more latitude how it can deal with breaches if they own the devices. Next slide, please. Employee handbook, have one. Deal with issues of working at home. Deal with you have to revamp them as the economy again is changing from the post-COVID or pre-COVID period to COVID to post-COVID. You need to address those things and make sure you have robust confidentiality provisions in your agreement. Next page, or handbook, I should say. Information security policy. What steps are people supposed to take to protect information? And have it explained to folks and have some training on it. Don't just say keep things confidential. Say hi, keep things confidential. Don't sit there and work at Starbucks where everyone can see over your shoulder. Don't discuss confidential information in a very public setting. Next slide, please. If things, what do you do with and without these policies? Well, I think a lot of it has to do with communication, training, have policies, make new policies, make sure you're as Jesse and Robin both mentioned, policies need to adapt and they need to change with time and they need to be updated under the law and updated under technology and where the economy is and what we're doing. So you always need to do these things and stay up to date. Next slide, please. Onboarding procedures, decide what you're doing onboarding with agreements, acknowledgements, training, and so you create that culture of confidentiality we talked about earlier with ACE. Next slide, please. Exit interviews, that's a robust process that should align with what you're doing with your policies, procedures, and what people sign. And also, a great recommendation, when people leave, grab up their computer and save their hard drive. or take their hard drive and load it to a database, to a larger drive. Keep it intact, so if something happens later, you still have that drive. A lot of people don't want to hang on to computers, but you can hang on to the drive, or at least download that drive to a source or repository. And if you need to go back and look at things, you can do so. Next slide.
Hey, Mike, I know we've got a
Yeah,
bunch of slides left.
there.
For those that are here at the top of the hour, maybe we give them the
Yeah,
CLE number.
Keep going. We'll go to the next slide. I think I have it on the next slide here. Next slide. Next slide. Next slide. And next slide. And keep going. Keep going. Keep going. There it is. And there we go. For CLE, you can see in front of you. You can scan this. It will then take you to a document. Look at the attendance verification code at the bottom, SS2514. Mark that down. You can scan this, and then the form will come up. You can fill it out and put this information in and get your CLE credit. If you have any questions, comments, concerns, something you want to discuss with Robin or Jesse or myself, email us, call us, text us. I also believe that the slides and this presentation will be available through our website. And we had a great time presenting today. Hope you found this useful.
All right, thanks everyone. Thank you very much. As you can hear, we've got more than we have time to talk about, and we've got another one of these each month this year. Next month will be about AI, and I'll hand it back over to Sela.
This concludes our webinar for today. The CLE code is on the slide now. Thank you for joining.